It is 3:39 on News Talk 710 KURV Afternoons with Roxanne Flores. There are two topics I want to discuss with our next guest. One of them being the recent Supreme Court justice decision on that cheerleader case, how she posted some profanity on her social media against the school. The school, I think, suspended her, something along those lines, which is why we have Quentin Brogdon. He's an attorney, my guest on 710 KURV. Quentin, thank you so much for joining me. I really appreciate it. It says here, Supreme Court rules for student in First Amendment case. Can you tell us what that case was about?
Good afternoon, Roxanne. Yeah, this case involved Grande, a cheerleader in Pennsylvania. She didn't make the cheerleading squad. She was a sophomore in high school, so she posted on Snapchat thinking it would go away permanently. Lesson learned there. A photo of herself and one of her friends with a raised middle finger and quite a few F-bombs about school and softball and cheerleading. And one of the coaches saw it, and then she's kicked off of the squad for a year, suspended for a year. And that's what happened as far as how the case goes up. It's one of the most important student speech cases in the last 50 years. The last one that probably was as important is a case called Tinker from 1969, where some students were wearing black armbands to protest the Vietnam War, and the Supreme Court in that Tinker case way back in 69 said that's their free speech right to do that. Schools can discipline students for speech, but it has to materially and substantially interfere with the school activities, and these armbands did not. Therefore, the school could not prevent them or discipline the children from wearing them. In this case that just went up involving the cheerleader, it was an 8-1 opinion. Stephen Breyer authored it. He's a liberal justice, but all of the conservatives except Clarence Thomas joined in. And essentially, the opinion held that schools can regulate some student speech, particularly if it involves bullying or harassment, threats to students and teachers. And the court rejected the idea that schools cannot regulate speech off campus. In other words, there are some circumstances where they can, but the court found in this case that the school district could not suspend her. Obviously, it's too late for her, but should not have suspended her, because if she was an adult and had made these types of statements, even though we might not like them, they would be protected by the First Amendment, the right to free speech. So even though it might be tempting to dismiss her words as unworthy of free speech protections, the court said she was entitled to them. And so that was the holding. Clarence Thomas dissented. He's a conservative justice, and he pointed out that schools historically could discipline students in these circumstances, and that he didn't think the majority opinion gave schools very much guidance on when they can and when they can't discipline students going forward.
So as long as, I guess the school has the authority to suspend a student or discipline them in one way or another, is if it's done on campus, or if it's done during like maybe a UIL event. Is that when they're allowed to discipline a student, if they do what this cheerleader did?
I think the rule is, when it's off campus, it's going to be harder for the school district to discipline, but they still can, particularly if it involves bullying, harassment, or threats to students and teachers. In this case, I think it's important to point out this cheerleader didn't mention anyone by name. She didn't threaten anyone. She didn't harass anybody. She just kind of popped off. Although,
she's 14 years old. Sadly, social media, I think, has ruined a lot of kids' innocence. But it's just, she's 14. She's upset. I kind of agree with the ruling. Like, did she need to be suspended? Probably, or for a whole year. What does this ruling now mean for schools in the future?
Well, it means that they don't automatically and necessarily get to discipline students for statements made off campus, that those statements need to be particular kinds of statements, namely bullying, harassment, threats to students and teachers. The problem is going to be going forward, bullying in my eyes might not be bullying in your eyes. Or harassment in my eyes might not be harassment in your eyes.
That's true.
So there's some gray going forward, and that's what I think Clarence Thomas was concerned about is it is not really a bright line test for a school district to follow the opinion. So we'll see. I predict this is not going to go away as an issue that we'll be hearing about.
What about when it comes to the workplace? You know, I know of stories where, let's just say, either you work in TV or you work in radio, and you say something on your personal Facebook page, and then someone in your HR department finds out, and they get what does that do now for the workplace? If you say something, maybe not against the job, or I mean your employer, or if it is your employer or client, whatever the case is, does this impact the workplace at all, this ruling?
Well, not directly and necessarily, but by implication it may. And here's the issue that we all need to understand. It depends who is regulating the free speech. If it's the government or a school, a public school regulating speech, that's a horse of one color, and that gets constitutional protections. If it is an individual, you know, I have the right to say in my house, I don't want people in my house who curse. If I chose to make that a rule, that's not unconstitutional. And likewise, private employers, provided they're not violating some other constitutional law wherein they're discriminating against someone on the basis of their sex, a national origin, religion, or something like that, they get to set the rules. And some of those rules obviously impinge on what people say on Facebook and other things outside of the workplace. So, yes, employers are going to have more power to limit what their employees say. Private employers are going to have more power to limit what their employees say than a school district would, or a governmental agency or entity.
Joining me on News Talk 710 KURV is Quentin Brogdon. He's an attorney, a legal expert, talking about the Supreme Court sides with cheerleader who wrote some profane things on her social media posts, slamming her school. Is there anything else, Quentin, when it comes to this specific story that we should know about? Because I want to ask you something else.
Well, I just, one final observation. It was interesting how, you know, we had liberal and conservative justices coming together, 8 of them, holding for the cheerleader. And then it was interesting to see who weighed in on behalf of the cheerleader. The ACLU, which is a very liberal group, conservative legal organizations, religious liberty groups, 9 Republican attorneys general, they all weighed in on the side of the cheerleader, and they aren't often on the same side.
On the same side
that they were in this case.
Wow.
As far as the school district, it was the Biden administration. They were in favor of the more rigid, you can be suspended rule. Wow. And then there were anti-bullying groups. So the Biden administration and anti-bullying groups weighed in on behalf of the school district. So sometimes these fights cut in ways that you might not expect it. It's not necessarily conservatives will go this way and liberals will go that way. It was interesting. This case is an illustration of that.
Now, what about a topic in a story like this, and I don't know, I'm pretty sure you can comment on it, how more than 150 employers resign or are fired from this Houston hospital system after refusing to get vaccinated. Can employers force their employees to get vaccinated, or what's like the legal side when it comes to that? And now, because everybody's pushing the vaccine and so on and so forth.
Well, I and many others have been saying for a number of months now that probably employers can require their employees to be vaccinated, particularly if those employees work in high-risk jobs like hospitals and nursing homes. And it's a balancing between, you know, the danger posed by not being vaccinated versus the potential jeopardy to people. But I've also said, and others have also said, that even for white-collar workers who don't necessarily come into contact with the public, probably employers can require vaccinations. The EEOC, the Equal Employment Opportunity Commission, the federal agency, said a number of months ago now that a vaccination is not a medical examination. And for lawyers, that's important because the law strictly controls the circumstances under which employees can be required to undergo examinations. And when the EEOC said a vaccination is not an examination, many people viewed that as at least removing one of the big potential roadblocks for employers requiring their employees to be vaccinated. So if it's not an examination, then it can be required in more circumstances than if it was considered to be an examination.
Yeah.
Now, interestingly, the EEOC said testing is an exam. So if you say, I want all my employees to be tested, they said that is an exam. And normally, we wouldn't allow those to be done readily and easily. But during this pandemic, we, the EEOC, are making an exception for COVID testing, and we're going to allow it. So I thought that was pretty interesting. Then we had two recent developments. The EEOC issued some guidance just a few weeks ago that says basically employers can require vaccinations. They made that very explicit as long as they accommodate their employees, religious beliefs or pre-existing medical. And then the case you alluded to, the federal judge in Houston dismissed the case brought by the employees of the hospital who were fighting the hospital's requirement that they be vaccinated. The judge dismissed it and said the hospital can require it. And then a number of them either resigned or were fired.
Yeah. Wow. That to me is just such a touchy subject because, oh man, like it would stink, Quentin, if like they, all right, because I don't have the vaccine, right? But Rox, you got to get it or else, But I'm like, okay.
Yeah.
What about, before we go, Quentin, what about, those passports that people are talking about, those COVID passports? Can employers require that? Or, what's the Constitution say about those COVID passports?
Well, our governor has said, has limited the ability of state agencies and certain other entities, the state schools, to require masks and vaccinations and things of that nature. But again, a private employer, the governor has not and almost certainly cannot prohibit that. So if an employer can require you to be vaccinated, I think an employer could certainly require you. The only way they could confirm you've been vaccinated is to have you show proof of vaccination.
Yep.
I think the Biden administration has said they're not going to require a national passport, and I can't imagine that our government in Texas would require a statewide COVID passport. In fact, I think they're even prohibiting it to the extent they can.
Yeah.
So I don't see that happening either at the state or government level, or federal level.
A private business, if they're in their legal right to do that.
Probably, and again, this is new stuff that's being worked out, even as we speak. But the consensus is probably employers can require their employees to be vaccinated, particularly for high risk, but even for lower risk. Lots of employers are not doing it. But, this particular hospital in Houston, they're in a high-risk environment, needless to say, and they were requiring it, and some of their employees were quite upset and went to court because of it.
Yep. Well, I know we're probably going to see so many more cases involving the vaccine or COVID passports in the future. But Quentin, thank you so much for joining us. Really appreciate it. That is Quentin Brogdon, a legal expert and attorney, my guest on News Talk 710 KURV.
Stay safe, Roxanne. Thank you.
Thanks.